Hello everyone, my name is Laxmipriya. Today we'll deal with the 6th chapter of Indian polity by M. Laxmikanth, that is citizenship. Article 5 to 11 under part 2 of the constitution, it deals with the citizenship. First let us understand one thing. India has two kind of people. One is citizen and the other is aliens. Okay, citizens are full members of Indian states and they enjoy all civil and political rights, whereas aliens are the citizens of some other state, so they doesn't enjoy all civil and political rights of India. Okay, again aliens are divided into two categories: friendly aliens and enemy aliens. Okay, friendly aliens are nothing but with those countries which we have cordial relationships. Okay, whereas the enemy aliens are the one with which India has some warlike situations. Okay, let us see the meaning and significance. The Constitution confers the following rights and privileges on the citizens of India. See, and denies to the aliens. All these are only available to the Indians and not to the aliens. Let us see one by one. Right against discrimination on grounds of religion, race, caste, sex or place of birth. Article 15. Okay, Article 16, that is right to equality of opportunity in the matter of public employment. Article 19, right to freedom of speech and expression, assembly, association, movement, residence and profession. Next is Article 29 and 30, cultural and education rights. All these rights are only to the citizens of India and not to the aliens. Okay, this is important. Next, let us see some more rights which are available only to the citizens and not to the aliens. Right to vote in elections to Lok Sabha and State Assembly. Okay, right to contest for the membership of Parliament and State Legislature. Eligible to hold certain public offices, that is President of India, Vice President, Judges of Supreme Court, High Court, Governors of States, Attorney General, Advocate General. Okay, all these are only to the citizens of India and not to the aliens. See, along with the above rights, the citizens also owe certain duties towards the Indian state. For example, paying taxes, respecting the national flag, national anthem, defending the country and so on. Okay, all these are only for the citizens of India and not to the aliens. Next, let us see the constitutional provisions. The Constitution deals with the citizenship from Article 5 to 11 under Part 2. However, it contains neither any permanent nor any elaborate provisions. Okay, this Article 5 to 11 of Constitution, they are not permanent but temporary. Many amendments are made to it. Next, it only identifies the person who becomes citizens of India at its commencement. That is on Jan 26, 1950. Okay, this Article 5 to 11, it identifies only the person who to become the citizens of India, but it does not deal with the problem of acquisition or loss of citizenship. Okay, it empowers the Parliament to enact a law to provide such matters or any other matters relating to citizenship. So in Constitution under Article 5 to 11, it only identifies the person who becomes the citizens of India, but the acquisition and loss of citizenship, it does not deal with it. So this acquisition and loss of citizenship is done by the Citizenship Act of 1955, which was made by the Parliament. Okay, accordingly the Parliament has enacted the Citizenship Act 1955, which has been amended from time to time. So far it was amended 8 times, recent one being in 2019. See, Citizenship Act of 2019 says that it gives the eligibility for Indian citizenship to illegal migrants who are Hindus, Sikhs, Buddhists, Jains, Parsis, and Christians from Afghanistan, Pakistan, and Bangladesh. So it didn't mention anything about Muslims. Okay, this was under the recent amendment which was done to the Citizenship Act of 1955 in 2019. Next. According to the Constitution, the following 4 categories of persons become the citizens of India at its commencement, that is on Jan 26, 1950. What are they? Let us see. A person who had his domicile in India and also fulfilled any of the 3 conditions. What are the conditions? If he was born in India, or if either of his parents were born in India, or if he has been ordinarily resident in India for 5 years immediately before the commencement of the Constitution, become a citizen of India. Okay, this is under Article 5. So a person who had his domicile residence, okay, domicile is nothing but residence in India, and fulfilled the following conditions. Either he was born in India, or either of his parents are born in India, or he has been originally resident in India for 5 years immediately before the commencement of the Constitution, that is 5 years prior to the 26th Jan 1950. If he satisfies these conditions, under Article 5, he will get the citizenship of India. Next, a person who migrated to India from Pakistan became an Indian citizen if he or either of his parents or any of his grandparents was born in undivided India and also fulfilled any one of the 2 conditions. See, next is a person who migrated to India from Pakistan. He will get the citizenship if he or either of his parents or any of his grandparents were born in undivided India, or else if they satisfy the following 2 conditions. What are they? He migrated to India before July 19, 1948, and he had been ordinarily resident in India since date of his migration. Understand? He migrated to India before July 19th, 1948. So if he migrated to India before July 19th, 1948 and had been ordinarily resident in India since the date of his migration. This is one condition. And the next condition is, in case he migrated to India after July 19th, 1948 and has been registered as a citizen of India. Okay. What was the first condition? If he migrated to India before 1948 and ordinarily resident in India. This was the first condition. And the second condition is, if he migrated to India after July 19, 1948 and has been registered as a citizen of India. Again, one more condition for this is, to register as a citizen of India, a person could be registered only if he had been resident in India for 6 months preceding the date of his application for registration. Okay, if he migrated to India after July 19, 1948 and if he stayed in India for 6 months, then only he can register for citizen of India. This is given under Article 6. Next, a person who migrated to Pakistan from India after March 1st, 1947 but later returned to India for resettlement could become an Indian citizen. For this, he had to be the resident of India for 6 months preceding the date of his application. Again, same. Earlier we have seen a person who migrated to India from Pakistan. Now under Article 7, a person who migrated to Pakistan from India after March 1st, 1947. Okay, and again he returned to India for resettlement. Then he would get the citizen of India if he had resident in India for 6 months preceding the date of his registration. Understand? This was given under Article 7. Next, a person who or any of whose parents or grandparents was born in undivided India but who is ordinarily residing outside India shall become an Indian citizen only if he has been registered as a citizen of India by diplomatic or consular representative of India in a country of his residence, whether before or after the commencement of the Constitution. See, what Article 8 says is, a person who or any of his parents or grandparents was born in undivided India but who is ordinarily residing outside India. Okay, they also will get Indian citizen only if he had been registered as a citizen of India by diplomatic or consular representation of India in a country of his residence, whether before or after the commencement of the Constitution. That is Jan 26th, 1950. Okay, this is given under Article 8. Next, the other constitutional provisions with respect to citizenship. See, under Article 9, no person shall be the citizen of India or be deemed to be the citizen of India if he has voluntarily acquired the citizenship of any foreign state. Okay, if any person voluntarily acquired the citizenship of any foreign state, then he doesn't get the citizenship of India. It was given under Article 9. Next, Article 10 says, every person who is or is deemed to be the citizen of India shall continue to be the citizen subject to the provisions of any law made by the Parliament. Okay, if any person wants the citizen of India, then if any laws are made by the Parliament, they are acted on that person. Okay, if any person wants the citizenship of India, then the laws made by the Parliament are also acted on this person. Next, Article 11 says, Parliament shall have the power to make any provisions with respect to the acquisition and termination of citizenship. Okay, acquisition and termination of citizenship, power is given to Parliament only. This was given under Article 11. Next, we'll see Citizenship Act of 1955. It provides for the acquisition and loss of citizenship after the commencement of Constitution. First, let us see the acquisition of citizenship. Acquisition of citizenship is done by, first, by birth, next by descent, by registration, by naturalization, by incorporation of territory. Okay, by incorporation of territories. So acquisition of citizenship is done by 5 things: by birth, by descent, by registration, by naturalization, and by incorporation of territory. First, let us see the acquisition of citizenship by birth. A person born in India on or after 26th Jan 1950 but before 1st July 1987 is a citizen of India by birth irrespective of the nationality of the parents. Okay, a person born after 26th Jan 1950 but before 1st July 1987. Okay, he will become the citizen of India by birth irrespective of the nationality of his parents. Next, after 1st July 1987 is considered as citizen of India only if either of his parents is a citizen of India at the time of his birth. Before 1987, he gets citizenship of India by birth and his parents doesn't play any role. But after 1st July 1987, the person will get the citizen of India only if either of his parents are the citizen of India at the time of his birth. Next, those born in India on or after 3rd December 2004 are considered citizens of India only if both of their parents are citizens of India, or one of whose parents is citizen of India and other is not an illegal migrant at the time of their birth. Understand? So the person who is born after 3rd December 2004 are going to get the citizenship of India only if both of their parents are citizens of India, or one of the parent is citizen of India and the other is not the illegal migrant. What is illegal migrant? Any person who came to India without proper documents, or who is staying in India beyond the time bound, all are considered to be illegal migrants. Okay, so the person born after 3rd December 2004, he'll get the citizenship of India only if their parents are, both the parents are citizens of India, or either of a parent is citizen of India but should not be the illegal migrant. Okay, next we'll see the acquisition of citizenship by descent. A person born outside India on or after 26th Jan 1950 but before 10th December 1992 is citizen of India by descent if his father is a citizen of India at the time of his birth. See, here it is talking about the father of person. Okay, person born outside India after 26th Jan 1950 and before 10th December 1992, he will get the citizenship of India by descent if his father was a citizen of India. Next, a person born outside India after 10th December 1992 is considered as a citizen of India if either of his parents is citizen of India. Okay. Next, from 3rd December 2004 onwards, a person born outside India shall be the citizen of India by descent unless his birth is registered at the Indian consulate within 1 year of the date of his birth, or with the permission of central government after the expiry of the said period. Understand? A person who is born after 2004, who is born outside India, he will get the citizenship of India only if he is registered within 1 year of his birth. If he didn't register within 1 year, he should take at least the permission from the central government. Then only he'll get the citizenship of India. Okay. Next we'll see the acquisition of citizenship by registration. First, a person of Indian origin who is ordinarily resident in India for 7 years before making the application for registration. Okay. So before making the registration, he should stay in India for 7 years. Then only he is allowed to he'll get the citizenship. Next, a person of India origin who is ordinarily resident in any country or place outside undivided India, he can also register. Okay, a person of India origin who is ordinarily resident in any country or place outside the undivided India, he can also get the citizenship by registration. Next, a person who is married to the citizen of India and is ordinarily resident in India for 7 years before making the application for registration. Understand? Who married the citizen of India and is ordinarily resident in India for 7 years before he makes the registration. Then he'll get the citizenship of India. Next, minor children of persons who are citizens of India. Okay, the persons who are the citizens of India have the minor children, he will get the citizenship of India through registration. Next, a person of full age and capacity whose parents are registered as citizens of India. What is full age and capacity? Full age is nothing but major. Okay, they are not minor, they are major. And full capacity is nothing but they are not mentally ill. Okay, they are not mentally ill. So the persons of full age and capacity whose parents are registered as citizens of India also will get the citizenship. Next, a person of full age and capacity who or either of his parents was earlier a citizen of independent India and is ordinarily resident in India for 12 months immediately before making an application for registration. Okay, a person of full age capacity or either of his parents was earlier the citizens of independent India and ordinarily resident in India for 12 months before making the application for registration, they will also get the citizenship of India. Next, a person of full age and capacity who has been registered as overseas citizen of India cardholder for 5 years and who is ordinarily resident in India for 12 months before making the application for registration. So OCI is okay, the person who is registered as OCI for 5 years, they can also get the citizenship of India. Next, we will see the acquisition of citizenship by naturalization. Naturalization, that is not being illegal migrant. First, that he is not a subject or citizen of any country where citizens of India are prevented from being subject or citizens of that country by naturalization. Okay, if an Indian goes to other country and if he doesn't get the citizenship in other country by naturalization, then the person from other country who has come to India for the citizenship, he also will not get the citizenship in India. Okay, any person who goes to foreign country from India and tries for the citizenship, if he doesn't get the citizenship by naturalization in that country, and if the person of that country comes to India, even he doesn't get the citizenship of India. Okay, next, if he is a citizen of any country, he undertakes to renounce the citizenship of that country in an event of his application for Indian citizenship being accepted. Okay, if any person renounces citizenship of that country for the application of the Indian citizenship, then he'll get the citizenship by the naturalization. Next, he has either resided in India or been in service of the government of India or partly the one or partly the other throughout a period of 12 months immediately preceding the date of application. See, if he is working under the government of India and living for a period of 12 months before the date of application, then he is allowed for the citizenship through naturalization. Next, during the 14 years immediately preceding the said period for 12 months, he has either resided in India or has been in service of government of India for a period amounting in aggregate of not less than 11 years. So prior to the 12 months, in 14 years, at least 11 years he should reside in India, or either he should work as in the government of India. Then only he'll get the citizenship through naturalization. Okay. Next, he is of good character or he has an adequate knowledge of languages specified in the 8th schedule of the Constitution. Okay, in 8th schedule we have 22 languages. What are they? Okay, Assamese, Bengali, all these are under the 8th schedule of Indian Constitution. Okay, so he should have the adequate knowledge of language specified in the 8th schedule of the Constitution. Next, the government of India may waive all or any of the above conditions for naturalization. See, the citizenship through naturalization is given only by the government, that is Parliament. Only Parliament has the power. Okay. Next, acquisition of citizenship by incorporation of territories. If any foreign territory becomes a part of India, the government of India specifies the person who among the people of the territory shall be the citizens. See, if any foreign territory is included in India, then government specifies, okay, if any foreign territory is included in India, then government specifies the persons who are in this territory shall also become the citizens of India. Okay. Next, special provisions to the citizenship of persons covered by the Assam Accord. All persons of India origin who came to Assam before 1st Jan 1966 from Bangladesh and who has been ordinarily resident in Assam since the date of their entry into Assam shall be deemed to the citizens of India as from the 1st Jan 1966. Okay, who came to Assam before 1966 from Bangladesh, they will automatically get the citizenship. Next, every person of India origin who came to Assam after Jan 1st 1966 but before 25th May 1971 from Bangladesh who has been ordinarily resident in Assam since the date of their entry has been detected to be a foreigner shall register himself. Okay, who came to Assam from Bangladesh after Jan 1st 1966 but before 25th March 1971, they all have the power to register themselves as a citizenship for India. Next, such a registered person shall be deemed to the citizen of India for all the purpose as from the date of expiry of a period of 10 years from the date of detection as a foreigner. See, those persons who are registered from the date of registration to the period of 10 years, he will get the access as a citizen of India. Okay, but the intervening period of 10 years he shall have the same rights except right to vote. He'll get all the rights of citizens of India for 10 years, but he doesn't get the right to vote. Next, let us see the loss of citizenship. Loss of citizenship by renunciation, by termination, by deprivation. Okay, first let us see loss of citizenship by renunciation. Any citizen of India of full age and capacity can make a declaration renouncing his citizenship. Upon the registration of that declaration, that person ceases to be the citizen of India. So any person can make a declaration renouncing the Indian citizenship. So if he once renounces Indian citizenship, he ceases to be the citizen of India. Next, loss of citizenship by termination. When an Indian citizen voluntarily acquires the citizenship of other country, okay, his citizenship automatically terminates. Next, by deprivation. A citizen has obtained the citizenship by fraud, or if he has obtained the citizenship by disloyalty to the Constitution of India, or if he acquired the citizenship unlawfully traded or communicated with the enemy during the war. Next, a citizen has within 5 years after the registration or naturalization been imprisoned in any country for 2 years. Understand? If we get a citizenship through registration or naturalization within 5 years, and in that 5 years if he is imprisoned for 2 years, then his citizenship will be deprived. Next, the citizen has been ordinarily resided out of India for 7 years, then also his citizenship will be deprived. He will lose his citizenship. Okay, next let us see the single citizenship. Though the Indian Constitution is federal and envisages a dual polity, it provides only a single citizenship. Okay, next, the other federal states like US and Switzerland on the other hand adopted the system of double citizenship. In US, each person is not only the citizen of USA but also of the particular state. Okay, in US people have dual citizenship, that is citizenship of US and citizenship of the state in which he is living. Okay, next, overseas citizenship of India. The Citizenship Amendment Act 2003 made provisions for acquisition of overseas citizenship of India by person of India origin of 16 specified countries other than Pakistan and Bangladesh. Okay, later the Citizenship Act of 2005 expanded the scope of grant of OCI for PIOs, that is person of India origin, for all the countries. Earlier it was only for 16 specified countries. Later in 2005 it was expanded to all countries except Pakistan and Bangladesh. Next, it must be noted here that OCI, Overseas Citizens of India, is not actually a dual citizenship, as the Indian Constitution forbids dual citizenship or dual nationality. Okay, as Indian Constitution, it doesn't have dual citizenship. Providing OCI doesn't mean that it is a dual citizenship. See, OCI holders, overseas citizen holders, doesn't have all the rights as a citizens of India. There are some regulations for them. Okay. Next. The Citizenship Amendment Act of 2015 has modified the provisions pertaining to OCI as a principal act. It introduced a new scheme. Okay, Citizenship Amendment Act of 2015 introduced a new scheme, Overseas Citizen of India card holder. By merging Person of India Origin Card Scheme and Overseas Citizen of India Card Scheme. By merging these two, OCIC was introduced by Citizenship Amendment Act of 2015, that is Overseas Citizen of India card holder. Okay. Now we'll see the registration of Overseas Citizens of India card holder. Any person of full age and capacity who is a citizen of another country but was a citizen of India at the time of or at any time after the commencement of Constitution. So the citizen of another country but was a citizen of India before or after the commencement of Constitution, he can register for the Overseas Citizen of India card holder. Next. Who is a citizen of another country but was eligible to become the citizen of India at the time of commencement of Constitution, he can also register to OCIC. Next, who is a citizen of another country but belong to the territory that become a part of India after 15th August 1947. Next, who is a child or grandchild or a great grandchild of such citizen. Okay. Next, a person who is minor child of the person mentioned in the clause A. Next, a person who is a minor child and whose both parents are citizens of India or one of the parent is a citizen of India. Okay. Next, spouse of foreign origin of citizen of India or spouse of foreign origin of overseas citizen of India card holder and whose marriage has been registered and subsisted for the continuous period of not less than 2 years immediately preceding the presentation of the application. Understand? Spouse of foreign origin of citizen of India or spouse of the foreign origin of OICC whose marriage has been registered for a period of not less than 2 years immediately after the presentation of the application. Then also he can register to the OCIC. Next, the central government may specify the date from which the existing persons of India origin card holders shall be deemed to the overseas citizens of India card holders. Okay, who are eligible for the OICs. So who are eligible for OCIC is determined by the central government. Next, the central government may, if it is satisfied the special circumstances exist, after recording the circumstances in writing, register a person as an overseas. Central government has the power to register the person as an OCIC if on a special circumstances if it is satisfied. Okay. Next, conferment of rights on OCIC. First, an overseas citizen of India cardholder shall be entitled to such rights as the central government may specify in this behalf. Next, an overseas citizen of India cardholder shall not be entitled to the following rights. Okay. As I said earlier, OCICs will be given the citizenship but with some regulations. Now let us see what are they. He shall not be entitled to the right to equality of opportunity in the public employment. Next, he shall not be eligible for the election of president. He shall not be eligible for the election of vice president. He shall not be eligible for the appointment as a judge of Supreme Court, judge of High Court. He shall not be entitled for the registration as voter. He shall not be eligible for being the member of House of People or the Council of States. He shall not be eligible for being the member of State Legislative Assembly or a State Legislative Council. He shall not be eligible for the appointment of public services and post in connection with the affairs of union or state. He is not eligible for SPSC or UPSC. Okay. All these are the regulations for the OCIC, Overseas Citizen of India card holders. Next, we will see the renunciation of overseas citizens of India card holders. Next, if any overseas citizen of India cardholder make in prescribed manner a declaration renouncing the card, registering him as an overseas citizen of India cardholder, the declaration shall be registered by the central government. Okay, if any person applies for the renunciation of the OCIC, this shall be registered by the central government. Okay, next, where a person ceases to be an overseas citizen of India cardholder, the spouse of foreign origin of that person who has obtained the OCIC and every minor child of that person registered as OCIC shall thereupon cease to be the OCIC. Okay, the person whose OCIC is seized. Okay, the person whose OCIC is seized, the spouse of that person and also the minor child of the person's OCIC is also seized. Okay, next, cancellation of registration as overseas citizen of India cardholder. See, the central government may cancel the registration of person as OCIC if it is satisfied that the registration as an overseas citizen of India cardholder was obtained by the means of fraud, false representation or a concealment of any material fact. Okay, then central government can seize the OCIC of that person. Next, the OCIC has shown disaffection towards the constitution. If a person shows his disaffection towards the constitution of India, then also his OCIC will be cancelled by the central government. Next, during any war in which the India may be engaged, unlawfully traded or communicated with enemy. Okay, any person who is engaged or unlawfully traded or communicated with the enemy, then also his OCIC will be seized. Next, within 5 years after registration has been sentenced to imprisonment for a term of not less than 2 years. If a person within the 5 years of his registration, okay, if a person is sent to jail for a period of not less than 2 years within the 5 years of his registration, then also his OCIC will be terminated. His OCIC will be seized by the central government. Okay, next, it is necessary so to do in the interest of the sovereignty and integrity of India, the security of India, friendly relations of India with the foreign country or the interest of the general public. If there is any threat to the security of India or relations with the foreign country, then also his OCIC will be terminated. Next, through the marriage of the OCIC cardholder. He has been dissolved by the competent court of law or otherwise. If a person is divorced, then also his OCIC will be seized. Next is has not been dissolved, but during the substance of such marriage he has solemnly marriage with any other person. If he is not divorced but married any other person, then also his OCIC will be seized. Okay. With this we are done with the citizenship. In the next session we'll start with the fundamental rights. Thank you.